Good morning, Judge Mogen. I still haven't been released, so I'm wondering if there is a problem.
Again, I've learned my lesson.
Continuing contempt, your reoccurring contempt, your ongoing contempt.
With Scout's honor.
Real-time transcript, what you said, that is not correct. In fact, that was a lie.
I ran this video about this man about 2 weeks ago. In that video, Judge Mogen sent him to jail for 90 days for contempt for disobeying her order regarding his Airbnb. I left a link in the description. In it, Mr. Auleciems never said anything about not owning the property anymore, but he did say he wasn't able to pay the $5,000 contempt purge. Today, he's paid it, and now he reveals he actually lost the property in a divorce back in December, long before the hearing 2 weeks ago. He remains every bit the sneaky bastard I said he was. It turns out he still owns many properties worth millions with his ex-wife, and he has a record a mile long, including tax evasion and felony swindling. I think he's right where he belongs. What's more, nerds?
We're here today in this matter on the motion hearing for Mr. Auleciems. He has filed, I believe, 4 documents. After being in custody, Mr. Auleciems did pay the total of $5,000 in the fines. And after that, Mr. Auleciems did send a letter to the court that said, "Dear Judge Mogen, I am sorry, ! I have paid the fines and I won't rent my cabin again until I have the county permit, ! Regardless of appeal, I promise, ! I was wrong about not getting the permit and I am truly sorry, ! I was selfish and not considerate of my neighbors. I ask for mercy and forgiveness," all underlined and capitalized. I have filings and a brief due for the appeal in a couple weeks, so I kindly and humbly ask you to release me today. Signed, a truly repentant and sorry Carl. On February 11th, the court did receive 2 letter motions from Mr. Auleciems. The first says, "Good morning, Judge Mogen. It's Wednesday, February 11th at 7:30 a.m. and I still haven't been released. So I'm wondering if there is a problem somewhere. Susan, who is his now ex-wife, is the sole owner of the property now, so I couldn't get licenses to rent the property now, even if I wanted to." And the court did receive another motion, written motion from Mr. Auleciems, looking more like a legal document, and says, "Motion to immediately release Carl Auleciems from custody, is unable to obtain licenses because as of the date of this affidavit, he is no longer the property owner of the Burnett property." He attached an affidavit, or what he believes is an affidavit, to the court in support. It has on top, "Affidavit of Carl Auleciems," with the legal caption. He states, "I, Carl Auleciems, under oath on Wednesday, February 11th, 2026, state that I am not renting the Burnett property. I am no longer the owner of the Burnett property. Signed this 11th day on February 2026 in Burnett County, Wisconsin." I do recognize that Mr. Auleciems believes that this is an affidavit. It is not a legal affidavit. It's nothing that the court can rely upon for multiple reasons. One, he states, "I, Carl Auleciems, under oath," but there is no person that placed him under oath. This is not signed in front of a notary. Secondly, he says, "Signed on the 11th day of February 2026 in Burnett County, Wisconsin." There is absolutely zero signature. There is no signature on this affidavit. It is not a legal affidavit. Therefore, it is not a legal affidavit that the court can rely upon. Therefore, the court needed to have this hearing because all I have is statements made by Mr. Auleciems, and at least to this point, his credibility is not held highly in this court. Can't necessarily believe what he tells me is to be true. And it's been shown time and time again, Mr. Auleciems wants to do what he wants to do, and he doesn't want to listen to the law. He doesn't want to listen to the court. He doesn't want to listen to the county. And if the court does not have authority over Mr. Auleciems, then I'm not sure what's left. That order was necessary as a sanction not only to terminate the continuing contempt of court, but also it was an order designed to ensure compliance with the prior order of the court, as it has been shown and proven clearly to the court that Mr. Auleciems does what Mr. Auleciems wants, not what is the law requires or states, and not what the court orders him to do. It would mean it would have to be intentional, as it was here, and it would be fitting for Mr. Auleciems' disobedience, resistance, or obstruction of the authority, process, or order of the court. The legislature has given the authority to the court's inherent power in this area to impose sanctions as the court deems appropriate. And that is exactly what the court did. The court deemed the jail sentences 45 days each, which is very reasonable in light of the fact that the court could have done something more, and did have it be consecutive. This was not a punitive, as in a summary sanction. This was a remedial sanction. And under remedial sanctions, the court may also provide a sanction to stop the past conduct so it does not continue in the future. In this case, the court does have Mr. Auleciems continuing to rent the property. He rents it for whatever period he rents it for, then he stops, then he rents it again, then he stops, then he rents it again, then he stops. So although Mr. Auleciems has argued, and I'll let him fill the court in as to his argument and what he wants the court to understand and to consider, he believes, at least how I'm understanding, that when you rent, then you stop because no one's renting, that stops the contempt, and then you rent, and then you stop, that stops the contempt. However, remedial sanctions are in place for situations exactly like this, which is ongoing conduct, which is conduct that continues for a particular time and stops, and where it's called, I believe, intermittent type of conduct or reoccurring contempt. And so that is exactly what happens in rental situations such as this. Therefore, even though there may be contempt for a rental period, it doesn't necessarily stop because no one is renting the next week. It is a continuing, reoccurring contempt. I did want to have this hearing so that I could allow Mr. Auleciems to be heard, because he does make statements, although he didn't make any statements at the time of the February 6, 2026 hearing, that he no longer owned the property, that he was divorced from Susan, and that she was awarded the property. He made zero statements that would even infer that that was the case. And in his first letter to the court apologizing, where he indicated that I won't rent my cabin again until I have the county permit, regardless of the appeal, I promise, leads the court again to believe that the property, the cabin, is still his property. The court then did have the need to set the hearing so that the court can understand if he in fact is an owner, if he isn't an owner, and why he didn't make any statement on the February 6, 2026 hearing, because that could have easily fixed all of this time that he has sat in jail, because there was nothing that the court had in its information or evidence or statements by any party that he no longer owned the property.
Well, again, Your Honor, we're here because I'm requesting immediate release because one of the purge conditions has been met and the other purge condition is not feasible and is not purgeable because I don't own the property.
I have reviewed every single statement that was made in that hearing. You had plenty of times because you kept saying my cabin, my cabin, my cabin, my cabin, multiple times. So at any time during that hearing, you could have said, I don't own that cabin anymore, but you didn't. And again, I've read it and it's like 95 pages long. So not one time did you say that. So I would think very clearly about what you're saying to the court. That's easily checkable because you are under oath.
The divorce decree was final on November 7th of 2025. And Suzanne is awarded sole ownership of the cabin in the decree. Suzanne then recorded a new deed with Burnett County in December. And if you look online, you will see that she is the sole owner.
Just so you know, I have the ability to be able to get a copy, but I don't now. I need to hear, because quite honestly, when I reviewed and read your motions, I didn't believe you.
Okay, well, I'm sorry you feel that way, but again, this is all verifiable fact. I'd be pretty big stretch to say that this divorce decree didn't happen and that she wasn't awarded the sole custody, sole ownership.
So I could read, and I'm going to let you know, I did read, and she was awarded that, but I don't have, I need the proof that it is no longer in your name and that you are no longer going to be associated with it in any way, shape, or form. I have ways I can do in order to get it, or I can get a copy of it. I'm not worried about that. I just want to know now that you're stating that it was awarded to your wife. I read, I confirmed that, and that you're telling the court that it was legally transferred to her name only.
That's correct, and that happened in December.
Okay, so I can look at that.
Yes.
All right. What else would you like me to know?
So then again, just technically the forfeiture purge has been satisfied. The license purge condition is not feasible because I don't own the cabin. And again, on the Larson case, the Supreme Court said that the purge conditions must be feasible and within the contemptor's power to meet. Obviously, if I don't own the property, I can't get a license. So that purge condition then is really irrelevant or moot, or because Suzanne now controls the property, not me.
Yes, and I need to get proof of that, and that's where we are. And I appreciate the fact that you went to the law library in the jail and that you found a book or something, and you wrote down all the case law and all the brief summaries of the cases. I know the law, Mr. Auleciems. I truly know the law. When I got your first letter, you didn't meet the purge conditions. When you got the second letter, you didn't meet the purge conditions. It wasn't until the third letter that I had any inkling that you may be unable to meet the purge conditions. Okay. And then with the additional motion, that's with the affidavit. If it was a signed affidavit, it would be stronger in the court of law, but it wasn't. But again, the 11th was the first inclination that I had that you may not be able to meet the purge conditions. And so that's why I needed to have a hearing so I could hear it from you. It wasn't signed under oath, or it wasn't signed declaring penalty of perjury or sanctions of the court. It wasn't signed at all. So anything else you want me to know?
Well, just that I'd like to be released immediately. I have a number of matters and affairs that it's causing irreparable harm. And I need to be released immediately.
I appreciate that, but your continuing contempt, your reoccurring contempt, your ongoing contempt, your intermittent contempt, all of that causes irreparable harm to the plaintiffs in this case, as well as to the county and the state, because you're not doing what you were ordered to do. So I get your argument of irreparable harm.
Right. So I don't own the property anymore. So I can't meet that purge condition. So
okay.
That's why I should be released.
Mr. Auleciems, is your divorce decree, are you appealing that decision from the court in Washington County, Minnesota?
Oh, I can give you that information too. So it is in appeal right now.
Well, I guess the only other question I would have then, if they accepted the appeal, it sounds like. So then the question would be, Mr. Auleciems, are you asking that the cabin in Burnett County be awarded to you on appeal?
Yes or no? It's a yes or no.
Yes. Yes.
So, Your Honor, again, we're not taking a position on his request to get out of jail, but the concern, of course, on behalf of my client is that, well, he may not be able to have satisfy the purge condition now, but it's something that'll come up in the future.
Whether I end up with the property back in the future. And if I do end up renting it, as I stated on my letter, I will get the necessary permits from the county and the state if I'm ever in that position again. So,
Okay.
again, I've learned my lesson. I give my apologies to the court. It's kind of a flaw of mine, my personality. Kind of pig-headed and stubborn. So again, I just want to offer my apologies to the court. And again, if I do end up in the position of owning the property again and wanting to rent, with Scout's honor, Scout's honor, I will follow your orders.
I appreciate your apology to the court, Mr. Auleciems. And I do understand that your argument is it's a negative characteristic trait of your personality. When I look at the divorce document, there are certain things I want to highlight, and because again, it affects Burnett County, it affects credibility, it affects whether or not the court does trust that you're going to abide by the court's orders. As to why it's hard to judge your credibility, Mr. Auleciems, not only from all of the statements that were made in court and proved not correct, but in the fact that you were found in contempt many times. But at the last hearing on February 6, 2026, the court did ask you about the payment for the transcript that you did owe to the court reporter, and the fact that that was a lot of difficulty for the court reporter to get the transcript. You indicated on the record that you paid that amount by Venmo in the morning. However, then the court's order went out in the afternoon, but that wasn't correct. And the court said, it's easily verifiable. There's records of when payments were made and when orders went out. And you said, yes, I paid it by Venmo before the court issued an order. That's not correct. That was... I said
I made the payment today. I said I made the payment the same day as your order.
Yep. And I have, again, I can read it from this real-time transcript, what you said. You did say that, but then you also said, I paid it before the order was issued. You said that multiple times in this record. If you want me to go over and read to you what you said, I certainly can do that. But you said, I paid it before the court issued an order. That is not correct. In fact, that was a lie, because the court issued an order, and then it wasn't until many hours later that you decided to violate the court's order and pay by Venmo when the court ordered strictly only payment by cash or check to the court reporter. And you paid by Venmo. Again, doing what you wanted to do and not what anyone else told you to do or ordered you to do. Again, with the whole credibility, this was brought up in another hearing, but the court did get the confirmation of it with regards to when I was looking for the findings of fact. The 10th District Judicial District criminal case in which you were convicted of multiple felonies and you were sentenced to 23 months in St. Cloud Prison, but it was stayed for 5 years, and that you must serve 45 days of that in the Washington County Jail, which you did. And the fact that you were convicted of, I believe it was 14 felony counts for swindling, tax evasion, or theft by swindle, tax evasion, and other multiple felonies. And so that goes against your credibility as well. So again, can you see why it's hard to believe your statements that you do not own the property, and the court needed to find assurance that you did not own the property? But I do not have any documentation that it was yet transferred to Mrs. Auleciems, or I don't know if she goes by Mrs. Auleciems anymore, but Suzanne. So I need to get confirmation that it was transferred to Suzanne's name only before I can see if you're unable to meet your purge requirements. All right, now I'm significantly behind on my calendar, but I will get an order out and make my determination after I receive the document.